Good day. My name is Charene Nortier, and I'm from the Financial Advisors and Intermediaries Department at the Conduct of Business Supervision Division of the FSPs. Essentially, what that means is that we supervise financial services providers and we try to assist them with any compliance-related queries that they may have. One of the issues that startup FSPs sometimes battle with is, do they need to appoint a compliance officer, and at what stage do they need to appoint a compliance officer? And then when they have appointed a compliance officer, what are the duties of those compliance officers and the relationship between the FSP and the compliance officer and between the compliance officer and the FSCA? So the purpose of today's recording is to try and unpack these roles in relation to the legislation. So we are going to be looking at a couple of different pieces of legislation today. The pieces of legislation that we will be looking at are, first of all, the FAIS Act itself, and then we're going to be looking at the regulations to the FAIS Act. We're going to be looking at two board notices, Board Notice 126 and 127, that were promulgated in 2010. And then we're going to look at the FAIS Notice 119 of 2017. That is an exemption notice. So we are going to be unpacking all of this and hopefully creating some structure for you as an FSP and also as a new compliance officer. So Section 17 of the FAIS Act tells us that an FSP must establish a compliance function and the requirements when they have to establish the compliance function. So to put it in a nutshell, the moment an FSP has more than one person in a regulated role in that FSP, it must appoint a compliance officer. So the moment an FSP is either one or more key individuals, or one key individual and one representative, or one key individual and more than one representative, so more than one person in a regulated role, then it has to appoint a compliance officer. So it says here for us in Section 17(1)(a) that any authorized financial services provider with more than one key individual or one or more representatives must, subject to certain sections, then appoint one or more compliance officer to oversee the provider's compliance function and to monitor compliance with this act by the provider and such a representative or representative. And then in particular, in accordance with the procedures contemplated in subsection 3, and to take responsibility for the liaison with the registrar. So we see here the compliance officer must take control of the compliance function. So the FSP establishes the compliance function. The compliance officer is then in control of that compliance function. The compliance officer must monitor the adherence by the FSP and its representative or representative with the provisions of the Act and the subordinate legislation. And the compliance officer must also liaise with the registrar, and the registrar here is nowadays read as the authority because the legislation was promulgated when it was still the Financial Services Board with the registrar, and with the changes in legislation we now read this to refer to the FSCA, to the authority, and then the reference to the registrar is read as the authority. So the person who is appointed as the compliance officer and in charge of the compliance function must meet the fit and proper requirements. So we will be looking at the fit and proper requirements for compliance officers as well. And it then says that the provisions of Section 8, capital A, apply with the necessary changes to a compliance officer. So we will be looking at that as well, but it's a continuation of the fit and proper requirements. And what is very important, that the provisions of Sections 19(4), 5, and 6 relating to an auditor of an authorized financial services provider also apply with the necessary changes to a compliance officer. So we continue to look at these provisions of Section 17 of the Act. A compliance officer must be approved. The registrar, in this sense now the authority, may at any time withdraw the approval if satisfied on the basis of available facts and information that the compliance officer has contravened or failed to comply with the provisions of the Act, does not meet or no longer meet the fit and proper requirements, or does not comply or no longer complies with the criteria and guidelines contemplated in paragraph A. So that is the criteria and guidelines that we set for compliance officers, and we will see those criteria and guidelines expanded on in board notices 1 to 6 and 1 to 7 of 2010, because that is where the guidelines are provided. So if we continue, then the registrar may make known any withdrawal or approval under the subsection and the reasons thereof. An authorized financial services provider must establish and maintain procedures to be followed by the provider and any representative concerned in order to ensure compliance with the Act. That's an important requirement for the FSP. Now remember what I said, the compliance officer must monitor the adherence by the FSP and its representative or representatives with the requirements. So here we see the FSP must establish it, and the compliance officer must monitor the adherence to those procedures that were established by the FSP. The compliance officer must then submit reports. So from time to time, we publish reports. It used to be the compliance report up to 2018. We are currently issuing requests for information on a regular basis, and we are planning an Omni CBR, which is an Omni Conduct of Business Return in the future. So as reports are established and published by the authority, then the compliance officer must make sure that the FSP submits those reports and that the reports are submitted in line with the requirements set by the authority for that specific return. So each return will have its own requirements, and it is important that the compliance officer must ensure that the FSP adheres to those requirements. And you'll see that there is continuation of the requirement that the FSP must at all times meet the requirements of the FSCA. If we look at Section 19.4 of the Act, then Section 19.4 talks to the auditor, and it says that despite anything to the contrary contained in any law, the auditor of an authorized financial services provider must report to and inform the registrar in writing of any irregularity, so that's something that's already happened, or suspected irregularity. So we're not 100% sure, but we suspect that it's happening. So the moment the auditor comes across something like that, they must report that irregularity or suspected irregularity in the conduct of the affairs by the FSP to the FSCA. Now, we read earlier that this section also applies to the compliance officer. So where the compliance officer comes across an irregularity or a suspected irregularity, he or she also has an obligation to report that to the authority. We take these reports very seriously and we give a lot of attention to it. The action that we take will depend on the materiality of the irregularity itself. So we don't have a standard action. Each case is analyzed and decided on the merits of that specific case. But you don't have a choice. As a compliance officer, you must report it. It is an obligation in law. So we refer to a Section 19.4 irregularity when it is submitted by the auditor, and the Section 17.4 irregularity if it is reported by the compliance officer. And it's just to differentiate between Section 17 talks about the compliance function and Section 19 talks about the auditor and the audit function. If we go to the regulations, regulations to the FAIS Act in Chapter 4 deals with the compliance arrangements, and it then cross-refers to Section 35(1)(c) of the Act, and Section 35(1)(c) of the Act says that the regulations must provide for compliance arrangements, compliance monitoring systems, and the keeping of the records. There are two regulations under the regulations to the FAIS Act that specifically addresses the compliance function. The first one is Regulation 4, and this talks about the application for approval. And essentially it says that an authorized FSP must submit an application for the approval of a compliance officer. And this must be done in writing in the form and the manner as determined by the registrar. So the authority has published forms that must be completed when an application is sought for the approval of a compliance officer. Regulation 5 then continues, and it talks about the establishment of a compliance function. In this section, it says that the FSP must ensure that the compliance function exists or is established as part of the risk management framework of the business. It must be supervised by an approved compliance officer or otherwise managed under the control and the responsibility of the provider alone. So when you are appointing a compliance officer, then the compliance officer must supervise this. The compliance function must be exercised, with the diligence, care, and degree of competency as may reasonably be expected from a person responsible for such function. So this mirrors to a large extent the wording that we find in Section 2 of the General Code, where we address FSPs and representatives. And it talks about diligence, care, and degree of competency. So the compliance officer must also know what they're doing. In a nutshell, that's what it says. And they must do it with care. Then it continues and it says that the approved compliance officer must provide a provider with written reports on the course of and progress achieved with compliance monitoring duties and make recommendations to the provider. So when a compliance officer has conducted any of the monitoring functions, after each monitoring activity has been concluded, the compliance officer must provide a report to the provider. So they could combine it and say that over the course of the last month, I conducted the following monitoring, and this is what I found, and this is my recommendation in respect of the findings that I make. The provider, that's the FSP, must then give attention to the report that the compliance officer issued to them. So that's what the regulation says. If we then go to Board Notice 1 to 6 of 2010, then this talks about the appointment of a compliance officer where that compliance officer is brand new in the industry. So it provides for entry into the environment where the compliance officer doesn't have the necessary experience and skills yet. Essentially, it provides for new entrants. So you have a qualification, you don't have experience. How do you get that experience, and what are our requirements that we've set out for you? So in Board Notice 1 to 6 of 2010, it says this is what you have to do when you want to appoint a brand new compliance officer. So the purpose is to gain experience under supervision, and the period under supervision is 3 years for compliance officers. They must pass the regulatory examination, the RE, within 24 months of date of approval, and they must have a relevant qualification. We differentiate between the requirements for compliance officers who seek approval for Category 1 and 4 FSPs and compliance officers who seek approval for Category 2, 2A, and 3 FSPs. So this mirrors the complexity that we also see for representatives under supervision. So you will see that it's a very similar approach. We are saying certain activities, certain environments are more complex, and therefore a little bit of extra supervision and support is required while people are gaining that experience. So if we look at year 1, the compliance officer under supervision must be accompanied whenever they go to an FSP, regardless of the category of the FSP during year 1. During year 2, we see that the compliance officer under supervision can go to an FSP and conduct certain monitoring activities, and they don't have to be accompanied while they're doing that. However, in the Category 2, 2A, and 3 space, the compliance officer must still be accompanied by a supervised, by an experienced compliance officer. So the supervisee, so that's the compliance officer under supervision, in a Category 2, 2A, and 3 space must also be accompanied during year 2. During year 3, in all of the categories, the compliance officer under supervision can go to the FSP unaccompanied by the supervisor. So the supervisor here still has some responsibilities as the period progresses, but they don't have to be with the supervision during the supervision period. They don't have to go to the FSP at all times. So it's unaccompanied monitoring of FSPs across all the categories in year 3. However, there are overall requirements and differences. So in the category 1 and 4 space, and we will see something similar in the category 2, 2A and 3 space, the compliance officer under supervision may not provide the final sign-off on the compliance report to the FSP. So that report can be drawn up by the compliance officer under supervision, but it must be checked and signed off by the person who is conducting the supervision. Let's just make that clear again. I'm the supervised compliance officer. I can contribute, I can draw up the report, but my supervisor must sign it off before we submit that to the FSP. If we look at the reports to the registrar, to the authority, so when the authority asks for a report, the compliance officer under supervision may not finalize it. They may not complete it on behalf of the FSP. It must be completed by the supervisor. So it must be completed by the person who already meets all of the requirements and is not under supervision anymore. And in the category 2, 2A and 3 space, during the 3 years, the supervisor must at all times approve the services that are rendered by the compliance officer under supervision. So there's a little bit more hands-on supervision required in the category 2, 2A and 3 space during the duration of the period. If we move to Board Notice 127 of 2010, this talks about the compliance officer's approval, and it also talks about the approval of the compliance practice. We also see that there is a differentiation between an internal compliance officer, so that is someone who is in the full-time employee of the FSP, and an external compliance officer, so that is someone who has contracts with more than one client, and they provide compliance services as an external compliance practice and a compliance officer to the FSP. So you will see that this board notice has been amended quite a number of times, and the most recent amendment was in 2017. So we differentiate between phase 1 approval and phase 2 approval. So phase 1 is the overall approval. So this is where a compliance practice is approved as a compliance practice. And the entities that can obtain approval as a compliance practice are limited to a partnership, a PTY limited, or a CC. A natural person cannot get approval as a compliance practice. It must be a legal person. A compliance officer, however, is a natural person, and that natural person can either work as an internal compliance officer for an entity. If I have a business in my own capacity, then I could appoint another person as my internal compliance officer. Alternatively, I can then enter into a contractual agreement with an external compliance practice who will then assign one of their compliance officers to provide compliance services to my business. So that's the way that a business can decide how they want to establish their compliance function. To be approved as a compliance officer, they must have the applicable regulatory examinations. We will unpack that just now. They must have 3 years experience in risk or compliance, and they must have at least 1 year's experience in the same category as the FSP itself. So if I have a category 1 FSP, my compliance officer must also have at least a year's worth of experience in a category 1 FSP. So part of that 3 years of supervision that they underwent must have been in the same category as my FSP is. The same will be true for any other of the categories. I just use category 1 as an example. They, as an individual, must adhere to the personal characteristics of honesty and integrity, and that is set out in Section 8 of the Act. There it is in the context of a key individual, but you then read it with the same differences to the compliance officer. They may not be an unrehabilitated insolvent, compromise with creditors, or be provisionally sequestrated or liquidated, as the case may be. So the person, as well as the entity, must be financially sound. They must have adequate communication facilities. So they must at least have an email address, they must have access to a computer that they can access their email addresses, they must have at least a cell phone so that people can contact them. And that cell phone must be available. So they must have some kind of arrangement, whether it is a cell phone contract or a top-up contract of some kind, so that they can make calls and that they can receive calls that people can contact them. You can't have a compliance officer that you can't get hold of. That's the basis. As an external compliance officer, there is an additional requirement that you must have a fixed business address and operational ability. So let's take a look at what the operational ability is for an external compliance officer. So the operational ability mirrors to an extent the operational ability requirements that we impose on FSPs. The operational ability requirements then, and I've copied this from the board notice, says that you must have adequate storage and filing systems, and the records must be kept safe. And that's similar as to an FSP. There must be control structures, processes, and procedures with reference to segregation of duties. So where there is more than one person working in the compliance practice, there must be a segregation of duties, and those segregation of duty allocation must make sense. Then there must be control of access to the premises. Again, that talks about the safekeeping and the safeguarding of information. Remember, compliance practice will also have a lot of very confidential information. So again, you want to make sure that they keep it safe from destruction, and they also keep it safe that other people can't have unauthorized access to their premises and therefore to the records. Access rights and data security on electronic data must be managed and it must be kept safe. And we all know the basic things like passwords and the strength of passwords, and that passwords must be changed on a regular basis. And all of this, again, is just to make sure that information is kept safe, both from destruction as well as unauthorized access. Physical security of the compliance officer's records. We often find that people have an office at home. Nowadays, we see that a lot. So where there is an office at home, that office, the information kept in the office must be secure. So the other people in the house or the other people with access to the premises must not have access to the records just because they have access to the premises. There should be business policies and control, system application testing. So if you are going to be using various systems, you must test it from time to time. You must make sure that you can retrieve records. You must make sure that you have access to the data. If you have recordings, then you must test that you can access the recording afterwards. Whether it's voice or video, it doesn't matter the manner of the recording, you must be able to access it, you must be able to retrieve it. Disaster recovery and backup procedures, again, very similar as for the FSP. You must check what is going to happen in a disaster. If your laptop gets stolen, if your laptop breaks, can you get access to the records? Do you have storage facilities? If you store data on other devices, how safe are they from theft, from destruction? Can you access them? Can you still access the information on them? And then lastly, a business continuity plan. So again, as I've been saying on a number of occasions during this recording, very similar requirements as what we impose on an FSP, we also impose on an external compliance officer. And all of this makes business sense. So if we carry on and look at the phase 2 approval, then this dealt with in terms of section 4 of Board Notice 127 of 2010. And it says that the registrar, so remember this is the authority, must be satisfied that an applicant and compliance officer practice have adequate resources available to ensure the efficient rendering of compliance services and the bold is my addition, direct access to and demonstrable support from the senior management of the provider. So why do we have that and why do I place emphasis on this? The function of the compliance officer is to monitor adherence to the legislation and to report on the adherence and the findings that they make. If the compliance officer monitors and reports on it, but they don't have access to senior management may not be aware of any shortcomings and problems that can exist right now or may arise in the future. Essentially, the compliance officer is a warning system that we've built. So they must warn the FSP and say, you're not adhering to the legislation, and because you're non-compliant, the following can happen. Or you're adhering at the moment, but we can see that this is going to be a problem in the future. So if you don't fix X, Y, and Z, you're going to run into trouble. Senior management must be made aware of this so that they can take the necessary steps within the business to rectify the situation. If this is not done, the business can really get into serious trouble. And the role of the compliance officer is to warn them, to caution them, and to help them to fix things before it becomes a problem. If you don't have access to senior management, all of this may be lost, or it may happen too late. That's why we want to see that the compliance function, that the compliance officer has access to senior management, that senior management will see their report and will view it with sufficient seriousness. We want you to take this seriously. If we continue, we see that the registrar, the authority, must be satisfied that certain things are in place before they approve the application. So, can you render the compliance services independently and objectively? We understand that there is a lot of debate about independence because essentially you have a contract with whoever you provide your service to. So whether that is an external contractual relationship or it is an employment contract, there is still a contract that guides this. But within that, there must be provision for the fact that you do have an independent view of how the business performs its function, and that you must be able to report on that, and that this report will be taken seriously. Then you have to avoid conflicts of interest in the rendering of the compliance services. This conflict of interest is very similar to the conflict of interest requirements that we've built into Section 3(a) of the General Code of Conduct. So if you're not sure what to avoid and how to mitigate it, then I would advise you that you go and read Section 3(a) of the General Code of Conduct and see how that will help you to resolve your actual or potential conflict of interest. Do you recognize it? If it is there, what can you do to either get rid of that conflict of interest or to then mitigate and disclose it to the best of your ability? Records, we've talked about record keeping and the safeguarding of records and the documentation. To assist the provider, so the provider here is the FSP, in the compilation of an appropriate compliance risk management strategy, to liaise with the authority and to conduct regular reviews. We're going to be talking about regular reviews because we've also set out certain time frames. So the time frames for the regular reviews for internal and external compliance officers are set out a little bit differently in the board notice. For internal compliance officers, it is to conduct a regular visit to the branches, the business premises, and the representatives of that FSP. For a Category 1 and 4 FSP, once a year. For a Category 2, 2A, and 3 FSP, once a quarter. If it is an external compliance officer, then there is a differentiation between the branches and business premises and the representatives. So branches and business premises must be reviewed in the Category 1 and 4 space once a quarter, in the Category 2, 2A, and 3 space once a month, and then representatives we see in the Category 1 and 4 space twice a year, and in the Category 2, 2A, and 3 space, it's also once a month. Remember that the reports must be issued at the same intervals as the visits, and the reports must include recommendations as how to rectify any instances of non-compliance, actual or prospective non-compliances in the future. An important other factor is that a compliance officer or compliance practice may not have more clients than they can provide proper and appropriate compliance services to. So we don't have a ratio. We don't have one compliance officer is equal to X number of clients. It depends on the size, the risk, the complexity of the FSPs that you are providing services to. The same can be set internally in a business as well. If you make one compliance officer responsible for too much, then they're not going to be able to provide a proper compliance monitoring and reporting service. And that's the principle here. Can you do this if you take into account the complexity of the businesses and the representatives that they are monitoring, the complexity of the business of those businesses and representatives? How much? How many? Can you get to them all? Can you do a proper monitoring? Can you do a proper reporting on it? Has it got any value? If you can't provide anything of value, then maybe you have too many. So we don't have numbers. It really is a case-by-case situation. Section 5 of this Board Notice 127 also makes provision for CPD compliance officers, but at this stage it hasn't been promulgated yet. Then it talks about a recognized qualification, and it gives us the requirements for the recognition of a compliance officer's qualification. One of the major differences between a qualification for a compliance officer and a qualification for representatives and key FSPs, sole proprietor FSPs and key individuals, is that in a compliance environment, we also expect that the qualification must have something in it that talks about the job of a compliance officer. So you will see that there is a whole list of subjects. I'm not going to go through the subjects in detail here. You can ask us questions if you have any questions about that. But it talks about the fact that it must be either a business-related or a legal-related qualification, and it must then contain elements of risk and compliance. Interestingly enough, Board Notice 127 of 2010 provides for an internal compliance officer to delegate certain of their compliance functions. So an external compliance officer cannot delegate, but an internal compliance officer can delegate, but there are specific situations and requirements for that delegation to be recognized. So the internal compliance officer may delegate to a natural person who is an employee of the FSP or a subsidiary of the FSP or of the holding company or a subsidiary of the holding company of the provider. So the natural person to whom is delegated must be working in either that business itself or a business related to the FSP. Or it can provide for delegation to an approved compliance practice. So as the internal compliance officer, I can delegate to an external compliance practice. So I can use their services. We see this in interesting situations. Sometimes when you want an independent review, they will delegate to an external compliance officer. And sometimes when the external compliance practice has an office or a footprint that mirrors the footprint of the FSP itself, then it might also be very practical for them to then delegate certain of the monitoring to an external compliance practice. So there are various ways and reasons why an internal compliance officer may from time to time delegate. But if they delegate, there are requirements. So the internal compliance officer must at all times have appropriate oversight of the person to whom they delegate. They remain accountable for the services that are rendered by the person to whom they have delegated. And they must maintain a register with the names of the person, the description of the delegated service, as well as confirmation that they have met the delegation criteria. There is also provision for the withdrawal or the lapsing of approval. We mentioned that earlier. And this will happen if the compliance officer or the compliance practice no longer complies with the provisions of Board Notice 127 of 2010. If the person does not meet the criteria for phase 1 approval, the phase 1 approval lapses, or if the person does not obtain phase 2 approval within a year of having obtained phase 1 approval. So you can have phase 1 approval, but then within a year you must be appointed by an FSP as its compliance officer, whether it's internal or external. Then the last thing that I want to mention, I mentioned that there is an exemption about period of review. And this exemption is found in FAIS Notice 119 of 2017 and exempts compliance officers, both internal and external, from Section 4.4 of Board Notice 127 of 2010. So this is an exemption of the prescribed review period. What it essentially says is that compliance officers are not restricted to the once a month, once a quarter, once a year, twice a year reviews. The compliance officer and the business must do a compliance risk review of the business, of the branches, the representatives, the complexity of that FSP, and it can then draw up that risk review from a compliance perspective. And so based on this risk review, this is how we are going to be conducting the monitoring. So you must take into account the nature, the scale, and the complexity of the FSP's business, the compliance risks of the FSP, the availability and the adequacy of off-site monitoring tools. Over the last 2 years, we've certainly seen an increase in the use of off-site monitoring tools, and off-site access to data from the FSP, business premises, the business units, and the branches of that FSP. So the more off-site tools are available, that could also influence how often and when the monitoring takes place. They must establish and implement a monitoring program that takes into account all areas of the FSP's financial services, activities, and relevant, remember the word key, relevant ancillary services, and ensure that the compliance risks and the changes to the risks are monitored. They must also review the monitoring program on a regular basis to see does this still make sense, because the business may have expanded in a certain area and they changed the monitoring program because the compliance risks of the business have changed. Then they must report to the FSP on the adequacy and effectiveness of the overall control environment. They must report on the identified risks and the deficiencies, and they must report on the remedies that they are recommending that the FSP must undertake. So there is an exemption, but the exemption has very specific conditions. I hope that this has helped you to understand how and when to establish a compliance function, who can be the compliance officer, and what you can expect from the compliance officer. Remember, the compliance officer is there as someone to assist you to manage and monitor the compliance risks of your business. It's a partner in making sure that your business is successful. And as the authority, we rely on the reporting of the compliance officer, whether it's internal or external, to the FSP. We rely on the fact that the FSP will take this seriously, that senior management will have access to and receive those reports on a regular basis, and will give due consideration to the recommendations that are made in those reports. If you have any questions, every FSP has a person at the FSCA's offices who looks after the authorized FSPs. So you will have an analyst who is responsible for the ongoing supervision of your FSP. If you have any questions, you are welcome to contact that analyst and take this up on an individual conversation. All the best and good luck, and thank you very much for listening to this. We'll speak again in the near future.